Chair, I can confirm we're now live.
Okay, thank you, Kirsty. Welcome everyone to this hybrid meeting of the Governance and Audit Committee. Please note the meeting is being broadcast and recorded. For clarity, voting is only permitted by members who are present in the room. Any member joining the meeting remotely is able to participate in the debate but not able to vote. Other than that, the usual rules apply. Are there any apologies?
Apologies from Councillors Wade, Badebo and Hayes.
And as I understand it, Councillor Green is substituting for Councillor Wade.
That is correct.
Okay, thank you. I also had apologies from Stuart McKellar, who is away. So I can see the members of the committee who are in attendance, and their names will be recorded in the minutes. Can the clerk confirm if any members are joining remotely, and if those members could confirm their attendance when Derek calls your name? Are there any there?
There are none.
There are none. In that case, thank you very much. The full text of declarations of interest is set out in the agenda. If any member has a disclosable pecuniary interest or an affected interest to declare, please indicate and I will come to you in turn. Councillor Hayden.
It's more to do with the last meeting than this, and I'd ask for Sanjay's ruling on this. The JV was mentioned, was brought up.
You haven't turned it on yet. I'll just speak into that one. Oh, Peter, speak into that one. Peter, speak into that one.
Right. Can you hear me? Certainly the JV was on the last agenda. Should I have declared an interest as a member of the JV board? So, in retrospect, can I have that recorded for the last meeting? It's not on the agenda this time, but I assume...
We could do that as an update to the minutes, couldn't we?
Is that all right?
Yeah,
okay, thanks.
Okay, we'll update the minutes.
Thank you.
Right, thank you, Peter. What did I get to? Yes, okay. In that case, for this meeting, there are no declarations, but may I remind anyone that you can declare at any time should it occur to you at a later point. Anyone declaring a disclosable pecuniary interest will need to leave the meeting when we get to that relevant item. Agenda item 3 is asked to approve the minutes of the Governance and Audit Committee held on the 22nd of June 2022. Councillor Hayden.
Could I actually make a disclosure of interest from the last meeting, being a member of the JV board? It's an affected interest, not a pecuniary interest.
Okay, can we record an affected interest for Councillor Hayden for the last meeting in the minutes?
Thank you, Chair.
Okay, any other comments in the minutes? In that case, can I propose the minutes?
Yes, seconded, Chairman.
All those in favour? Minutes are agreed. Thank you very much. The next item on the agenda is the consideration of any urgent items. Are there any?
There are no urgent items of business.
Okay. In that case, moving on to agenda items. Hang on. Why have I missed out agenda item 6? Let me just check that. Check the agenda.
It's item 5.
That's what I thought. It's 5. It just says 7 in my notes. That's right. Okay. So agenda item 5 is to review the special severance payments statutory guidance report. Sanjay, I understand you're presenting this item.
Thank you, Chair. Yes, I am. I will be brief. I'm hoping the report and the attached document are self-explanatory, but if I just go through very briefly the main themes. So first thing I ought to say is that initially this was going to be an information report because it relates to statutory guidance and the government's expectations, if you like, through the guidance in terms of how local authorities will implement their processes around special severance payments. However, because of the fact that there is a requirement to amend the constitution to reflect the delegations that are implicit within the guidance, I've brought this report to Governance Audit Committee and it will have to go to Council in order that those delegations can be adopted in due course. So the report itself deals with guidance, statutory guidance, which the Council needs to, at the very least, have regard to relating to payments, exit payments, essentially that are made to members of staff by local authorities. It doesn't relate to contractual or statutory redundancy payments, and I want to make that clear. It's referring to payments which are defined as special severance payments, or referred to as special severance payments. And in the document itself, and I've referred to this in paragraph 5.2 of the report, it refers to, or it itemizes, what we should consider to be likely to be special severance payments. So an example of that is a payment reached under a settlement agreement to discontinue legal proceedings without admission of fault. That's just one example. There's examples that are given in the guidance which may constitute special severance payments, and there are examples where payments wouldn't constitute special severance payments. And the example I just gave in terms of contractual and statutory redundancy payments are included within that. The thrust of the guidance is that there's a view within central government that perhaps councils are too whimsical in terms of granting payments, settlement agreements, or entering into settlement agreements and exit agreements, and they want to make sure that there is a clear line of audit when those payments are made. So essentially they're saying that under the reflected in the best value regime, we need to make sure that any payments reflect the best value responsibilities of local authorities in terms of achieving best value through effectiveness and efficiency, in particular efficiency and effectiveness. And what does that mean in practice? Well, in practice, it's saying that if we are going to, as an authority, be involved in granting exit payments which constitute special severance payments, then there needs to be a clear process which establishes that they meet the best value duty. And the way to do that would be for there to be a check, and that would normally be somebody, the Section 151 officer, or one of his or her delegates would essentially reach a view on whether or not the settlement concerned or the payment concerned meets the best value duty in terms of whether it is value for money and being consistent with the best value duty. Secondly, in terms of the appropriateness of a payment, as a monitoring officer, there has to be a legal basis for those payments in the future as well. And essentially that means myself or one of my delegates would be able to give a view before any such payments are made to ensure that all alternative avenues have been explored before an agreement was reached. It's also quite noticeable that the guidance does say that and I think this is an important point for local authorities, that we shouldn't just be entering into agreements or settlements on the basis of the fact that the issue of commerciality, in other words, it's going to be more expensive to actually oppose a case in the tribunal. I think they want to make sure that irrespective of that, if a payment is made, that we've established that it represents best value for the council on the basis that it is taxpayers' money that is being used in those processes. Now, in actual fact, those processes do take place now. So before we enter into a settlement agreement, ordinarily, myself or one of my delegates, HR and finance would normally be involved in the process in any event, but that's not something that we've done formally, and it's not something we've documented. So what this report suggests is a procedure which is included as an appendix, which actually sets out that before special severance payments are made in any individual cases, there will be a documented process which includes the Borough Solicitor's comments, the Assistant Director HR's comments, and the Section 151 Officer's comments, to ensure that we, as particularly the latter two statutory officers, are satisfied that those best value requirements around economy, efficiency and effectiveness have been established. And in terms of, again, going back to the guidance itself, in terms of economy, the guidance says local authorities should be able to demonstrate their economic rationale for behind the special severance payments. So the kinds of things that we will be looking at is, or are whether any feasible possibility of exiting the individual at a lower cost would be possible, how the exit payment would be perceived by the public, what alternative use could be made of that expenditure. So it's essentially a process which involves us ensuring that no payments are made where the payment relates to special severance payments without due process that's being followed, having regard to the best value duty. So I'm not going to say anything more than that. I'm sure that you've read the documentation. It does set out what constitutes and what doesn't constitute a special severance payment. I have shared this with the Assistant Director, HR, and Section 151 officer as well, so they are fully aware of this, and the report has gone through the corporate management team as well. If in terms of the decision for this committee, essentially it's the decision about approving the delegations that are referred to within the recommendations, because those are the delegations that will be put forward to the council for inclusion within the constitution. The rest of the document is largely for noting, because the guidance is the guidance, and we are under a legal obligation to have regard to that anyway. So I'll stop there, but I'm happy to take any questions anyone may have.
Actually, I wouldn't mind kicking off the questions myself. The first one would be, are you aware whether we have actually ever made any special severance payments? Certainly the last 20 years or so.
Yes, we do make payments. When we talk about special severance payments, essentially where there's an employment dispute, for example, and the payment that's going to be made may include ex gratia payments or compensatory payments as a basis. You could refer to them as nuisance payments. We do have a handful every year across the council. So yes, in answer to your question, Chair.
And my second question was, I noticed that the government document was dated the 12th of May this year. Is it a new document or an update? Do you know?
I think there are similar provisions within a SITFA document, and I think the rules may already be applying to some extent in central government, but this is a new document itself.
Thank you. Councillor Green.
Yes, thank you. On these, do you keep the person's name private? So if it goes through and it has to go to full council, is it something that if someone did a freedom of information request, they could get at the whole details of that person? Or is all that kept private? So it's just between whoever signed it and that, but it would be a person as it went through?
Yes, thank you, Councillor. Yeah, we wouldn't normally disclose the individual's name. Normally that would be confidential, both as an exempt item in terms of council procedures and under the Data Protection Act as well. We wouldn't disclose.
Councillor Brossard.
Thank you much. Thank you, Sanjay, for that. 3 short questions. I'm very pleased to see that there is an element which makes reference to frivolous or vexatious claims, where in some cases it may be appropriate for us to fight it rather than to settle at a lower figure. I think that shows obviously a determination by us to secure justice, and I think that is right. The bandings that are referred to in the report, which go up Chief Executive and then full council, are those government guidance bandings, or are they ones that the individual council can choose to set up?
So my understanding is that that's set out in the guidance, so there is discretion for councils to deviate from them, but the report I've produced is reflecting those thresholds. So council for anything above 100,000, which is very exceptional, I've got to say. I don't think in the last 20 years we would have had a case which involves a settlement in excess of 100,000. So it's the exception rather than rule. But we would have had quite a few between 20 and 100,000. So that's something to bear in mind.
Final one, if I can, Chairman. How do we deal with non-disclosure agreements? Is this a situation that can arise, that a settlement is reached, but there's an agreement of non-disclosure? That's not referred to in the report, and I just wonder how we treat those situations.
So Councillor, non-disclosure agreements, we do have provisions within our settlement agreements, what used to be called compromise agreements, which would include provisions where there would be an obligation on both the part of ourselves as the employer and the employee not to discuss the terms of the settlement outside, for example, immediate family, or in our case, outside the council itself. So, I mean, that's the non-disclosure agreement in the context of employment settlements. And I think that's standard practice, largely.
Then can I just very briefly, Chairman, follow on? If someone was then to disclose outside the immediate family, what are the repercussions? Are we able then to take an injunction against them or recover some of the costs of some of the payments that have been made? It's a hypothetical question, but it's probably worth asking.
No, I think it's a very, very legitimate question. We obviously, if somebody did then disclose outside, so for example, just maliciously wanting to share information outside in terms of a settlement agreement, we could bring a claim for breach of contract because a compromise settlement agreement would, to all intents and purposes, be a contract. It's very difficult to recover any monies, I've got to say. I think that's always going to be difficult. I think the injunction is the route. Again, the problem is, you know, if the information is out there, it's already out there. So if it's on social media, there are other routes you can take to take down posts. But the difficulty in those situations is once there's a breach, we're always in a difficult situation.
Thanks, Chair. It's really a clarification. Am I right in thinking that exceptional circumstances can be outside the statutory law, provided it's legal within itself?
I'm not
It
quite
just
sure I
seems to be all
understand, sorry.
contradiction. It's 3.1 and then on 5.2, I think it's, is it, which bullet is it? 1, 2, 3, 4, 5. The sixth bullet.
In the report or in the guidance?
In the agenda, the special severance payment statutory guidance. It's page 8 and 7.
So the reference to exceptional circumstances is just that. I think the expectation on the part of government is that these payments should be the exception rather than the rule. That's the first point to bear in mind, that there shouldn't be an automatic presumption that we can move to make a settlement without having regard to the best value duty. And I think that's all that's saying, so when it talks about exceptional circumstances. In terms of the document itself, sorry, you referred to a particular paragraph where...
It's actually the 4th paragraph down on page 8, where it starts, indicates there may be exceptional circumstances.
Sorry, that's in the, it's in the papers.
Oh, sorry.
It's the bullet points. It's the bullet point you just talked about.
Oh, right. Okay, sorry.
It's the 4th one down.
Indicates that. Okay. Indicates there may be exceptional.
I was a bit concerned in case there was a contradiction.
Sorry, did you say the 4th bullet point?
It's the fourth bullet point down that starts, indicates there may be exceptional circumstances.
Thank you. Yeah, so this is a situation where it's likely to be a special severance payments in relation to what the guidance is saying. Indicates that there may be exceptional circumstances where the existing statutory or contractual entitlements are insufficient to facilitate an exit. So what that's effectively saying is that we may in certain situations want to agree an exit, and we may be looking at just the statutory payments, the redundancy payments, but for whatever reason, negotiations don't proceed to the point where a settlement on that basis is accepted by the employee. And in those cases, then yes, you know, we can proceed to a special severance payment, you know, but that's implicit within the guidance itself. So it refers to statutory redundancy payments and contractual redundancy payments. Sorry, that. Apologies, let me just read it in because I'm just looking at the wrong bullet point. I apologise. Indicates there may be exceptional circumstances where the existing statutory or contractual entitlements are insufficient to facilitate an exit. So it may be a case where somebody's going to exit. It may be based on a redundancy payment, but that can't we can't get an agreement on that. The person might be entitled to other payments, statutory payments like unpaid annual leave, so we would add that in. If there's any other payments that are due for whatever reason, all those contractual payments, entitlements aren't sufficient, and in those cases we can, but it has to be based on professional advice, and that's what that bullet point is essentially saying.
Right.
So if the contractual entitlements aren't sufficient to get an agreement, then it can be possible in certain situations, but but the presumption is that it wouldn't be a special statutory payment in those situations, and that's the thing to bear in mind. The burden, the expectation is that it wouldn't be a special severance payments unless the professional advice is that the payment should be made. So the presumption is in those situations we shouldn't go ahead.
Chair, and can I just take it that the monitoring officer is sufficient to give that professional advice?
Yes, so it wouldn't be purely the monitoring officer. If you look at the appendix where the document which has been agreed by CMT, the advice would be advice from the Borough Solicitor Monitoring Officer, Assistant Director of Human Resources and Organisational Development, and the Section 151 officer. So it's a combination of views. It's the efficiency part of it, which is a financial assessment, if you like, and there's the other element, which is the appropriateness of the payment per se, based on the strength or weaknesses of the council's case. If I'm asked about a particular case to advise upon, if it's clear that the council, in my view, as an employment lawyer, which is my background, the council's case is weak, then there is a greater presumption then to look at settlement. If that's not the case, if we have an arguable case, then we should be looking at defending defending any future action, and that's the expectation within the guidance itself. The problem sometimes occurs, and I think this is the practicalities, is that we will sometimes go for what are known as commercial settlements, and the basis of those is that it may be that the employee or the representative is asking for a certain amount of money as a basis for not taking the case to a tribunal. We offer less, but we're also mindful of the fact that if we do take it to a tribunal, there's the cost of potentially external legal advice and counsel, and also officer time. And if it's senior officers involved, then that sort of has to be built into our calculations, and that's something that's done from time to time. And it's a reality of a small authority such as Bracknell Forest, where we can't afford necessarily to have senior officers out at tribunals for days on end, and I think that's been a feature in the past. I think what this is saying is you can do that, but I think we have to be very, very careful, and the grounds would have to be clearly made out.
Last question. Finally, on the other consultation responses, 6.3, you say the Assistant Director of HR, etc., was consulted. So what? Is that sufficient in itself, or should there be a rider to that?
No, I mean, essentially, it's a question of the guidance is the guidance, it's statutory guidance. We could do nothing about it. We could just simply note it. But I think the purpose of this report is to socialise the requirement amongst members of this committee and council, and also through CMT, which we've done, but also to formalise the process, have a formal process in terms of the due diligence, which is what we've discussed, and finally also having a process in terms of agreeing the delegations, which obviously is reserved to council, which we have to do. We can't ourselves have a process, because the delegations will go in the constitution. They ought to go in the constitution alongside the other delegations within the constitution. So therefore there was a requirement for that. But in terms of so what, this report I produced, it could be in the Assistant Director of HROD presenting this report. It was a flip of a coin. I agreed to do it, but it's a report where we have joint ownership of.
Okay, it wasn't intended to be as rude as it sounds.
No. I just wanted to make sure that you were aware that this has been agreed and prior to the report going to corporate management team. Thank you.
Councillor Leake.
Thank you, Chairman. The bullet point on page 8, the second bullet point, which you've talked about in relation to sort of employment matters and easing people out on a commercial basis, I'm assuming, given that category, and I'll come back to it in a moment, are there any other particular circumstances? I mean, for example, I assume that the intention here is not to find a mechanism to enhance people who leave under normal circumstances.
That's right. I think the expectation is the default position should be to the contrary unless we provide evidence that is consistent with our best value duty.
Thank you. The only comment I want to make on the examples that you've given is, while I understand the commercial reality over some of this in some cases, there's obviously a line, isn't there, somewhere between taking that view and taking a line which is the line that a responsible employer would take. Because if you use this too often, then it becomes, well, we'll get some money out of it somehow or other, rather than dealing with, particularly if it's an employment issue or a disciplinary issue, particularly dealing with it on that basis. Can you give us some assurance on how that judgment is made?
Yes, I think that's a really, really important point. One has to go back to the point that this is guidance first and foremost, so this isn't statutory law. So we have to have regard to it. It's actually statutory guidance, which basically means that we shouldn't really deviate from it without good reason. The main purpose of making sure that we're adhering to it, it's not so much the threat of litigation if we don't. It's more an audit question. It's about making sure that any payments that go out, particularly as they will be now reflected in the annual accounts, are properly justified, because you have to remember that there are, as you will be aware, mechanisms for members of the public to object to the accounts. And I've certainly worked in one authority where that did happen, where there was an agreement with an outgoing head teacher, not in Bracknell Forest, I should add, where somebody did object based on to the accounts based on the payment that had been made to the head teacher as a settlement agreement. So I think that's where we need to be very careful in terms of the external auditors. And so now that we have this guidance, I think we auditors will be keen to ensure that we have complied with these duties as well. I think that's the basis, but the guidance as it is itself, I think, affords us sufficient flexibility to make judgments, and I think that's your concern, Councillor Leake.
Yes.
And so we're not, we don't have to slavishly adhere to it. I think that's the important point, and the point is an important one. I absolutely get. In the real world, there are factors both, in support of going to battle, if you like, and in support of deciding when to choose our battles, and I think this does give us sufficient latitude.
Thank you. The other comment I'd like to make, and I'd like your view on it, is if we go to Appendix C, which is your special severance payment document, and presumably this is intended to be the mechanism whereby authority is given. That's right, is it? Yeah,
That's right.
I noticed that nowhere is there any member involvement at all. My own view is, I think that's an omission. There may well be discussion about what level and what member involvement there needs to be, but I personally am unhappy about the fact that, without casting any dispersion at all, that there simply seems to be an officer approval system, and I feel there should be some member involvement and sign off in it.
So the way I'd answer that, Councillor Leake, is that the Appendix C refers to the professional advice. In cases of payments above 100,000, of course, that would require sign-off by full council. Yeah. So that's the first thing to bear in mind. For payments between 20 and 100,000, and this reflects the guidance, that has to be signed off by the head of paid service, the chief executive, but again reflecting the guidance with a clear record of the leader's approval. So if you look at the end of that Appendix C, you'll see there that's referred to. So the commentary will be in the table, but if you look at the end of that document where it says approved, we will have the executive director for payments below 20,000, chief executive for payments between 20 and 100, but with approval from the leader. So there would have to be sign off from the leader in those cases and full council.
Forgive me, but on the copy I'm looking at, it doesn't say leader.
It doesn't say leader, but sorry.
Under
Yeah.
Appendix B, it does.
Oh, onto Appendix B. So should that not be reflected on the document then?
I can certainly add that. That's an omission on my part. I think if you look at the statutory guidance, it says with a clear record of the leader's approval. So
But where is that approval?
Yeah,
That
that's right,
is the question.
no, I think that's a fair point. And if you, what I can do is add a line there to ensure that
Yeah.
the reference is explicit
Yeah.
rather than implicit.
Thank you.
Councillor Green.
Just one final question. When there's a non-disclosure agreement, there's often in companies they pay an amount towards legal costs for them to look at it. Do we do the same in these circumstances with one of these?
So we do so where the payment is made formally through a settlement agreement, and in those instances there is a requirement in law. There's a requirement in law to ensure that the employee has had legal advice, and it's the convention is that we do pay for those legal fees, and they tend to be in the region of about. I mean, as a council, we tend not to go beyond around £400 for that. In essence, yeah, in essence, all the person will be doing the legal advice for the employee will be. It's to ensure that the legal advice has been taken. So it's an equality of arms issue. In other words, that the person hasn't been kind of corralled into agreeing something that they wouldn't otherwise without legal advice.
Thank you.
Do we need to draw a distinction between a non-disclosure agreement, which has got certain annotations, and an agreement which is private and confidential between the parties?
So,
because I understand that the two are different.
The two are different, but in reality, in this context, if there are any concerns about the employee coming back and trying to renege, then we would always enter into a formal settlement agreement, and the non-disclosure clause would be in that agreement. I've never come across a case where, in an employment context, where we've just entered into a non-disclosure agreement. It's not something that we do.
Yeah, thank you.
Councillor Brossard.
Thank you very much, Chairman. Sanjay, you mentioned about the annual accounts and obviously the amount of information that we provided. How will we tackle a freedom of information request if the desire is to get more information in terms of the level of settlement, without obviously redacting names and such like, but have we looked at the question of freedom of information?
If the agreement was under a settlement agreement, then we would rely on the confidentiality clause within that, as the chair has said, so it would be confidential. There is, I'm not an expert on data protection law. I have a lawyer who does all that for me, but I think there is, in terms of the protection, that kind of does reduce over time, in the same way when we're talking about commercial settlements. There's no absolute confidentiality in relation to settlements, so we do have to be mindful at some point the ability to keep awards confidential might lapse, but in reality we've not faced that situation.
I have to say, I mean, all this stuff is discussed under, in the pink, shall we say? So it never gets published, and therefore, under freedom of information, you can't ask the question. Well, you can ask the question, but you can't get an answer.
That's what I was thinking. Thanks, Chairman.
Are there any further questions? In that case, can I propose the recommendations on page 7 of the papers? 2.1 is to note the contents. 2.2 is the recommendation that Sanjay mentioned earlier, to recommend to Council that the delegation set out in Appendix B, and 2.3 is just to note the contents of the pro forma appendix, which Sanjay is going to make that alteration to, as suggested by Councillor Leake. Do I have a seconder?
Seconded.
Okay, thank you. Whoever. All those in favour? That's carried. Thank you very much. That's unanimous. Well, thank you for that. That's the last item on the agenda. Thank you for your attendance. And can we come off a line, please, Kirsty?